3 coats were gone from the nursery pegs by noon. The boys were gone with them. Fletcher, who was 7, Brinsley, who was 5, and William, who was not yet 3. Caroline Norton stood in the doorway of the room and understood, in the space of a breath, that under the law of England, not one thing in it was hers to claim. Not the cot, not the coats, not the children. The pegs were empty at a child's height. 3 brass hooks screwed into deal, and the morning light came in cold and thin across the boards. A tin soldier lay on its side near the fender. Somebody had swept around it. She was 28 that spring. Her husband was a barrister, a magistrate, once the member for Guildford, and he had done nothing that any court in the kingdom would call wrong. He had taken his own property out of his own house. That is what the law said the children were. That is what the law said she was. This emptied room would cost her the next 3 years. One of these children she would not hold again. So the question stood in the doorway with her, and it did not go away for the rest of her life. How does a mother, the law says, owns nothing? Not her money, not her name on a title page, not the sons she carried, ever get her sons back. She went down the stairs. She did not take the soldier. 9 years earlier, at a table in Great George Street, the same woman had been 19, and the most amusing person in any room she entered. Caroline Sheridan had a famous name and no money at all. Her grandfather had written The School for Scandal and died in debt with the bailiffs at the door, and the family had lived ever since on the interest of a reputation. There were 3 sisters. There was a widowed mother in Grace and Favour Apartments at Hampton Court. There was, in the whole of it, nothing that could be called a fortune, and 3 daughters who had to be got off somehow. She could sing, she could draw. She wrote verse that people copied out and passed along, and she could hold a dinner table for 2 hours with nothing but her voice and her hands. George Chapel Norton came to look at her when she was 16 and came back for her when she was 19. He was a barrister without much practice and a Tory member for Guildford without much conviction. The younger brother of a lord, heavy through the shoulders, slow in speech. He had prospects. That was the word the family used. Prospects. They married in July of 1827. At their own table that first winter, she took a room apart. A guest said something clever about Canning, and she said something cleverer, and the laugh went round and came back to her. And George sat at the head of his own table with his glass in his hand and waited for it to stop. It did not stop. It ran on for 11 minutes, one story into another, and every eye in the room went where her voice went. Afterwards, he said the guests had stayed too long. "They stayed for you," she said. "They stayed," he said, "because you would not let them go." She began to publish. The Sorrows of Rosalie in 1829, then The Undying One, then the magazines, then the editorship. She wrote quickly and well, and she was paid for it, which was the part of the arrangement nobody in the family had quite expected. The money came in banker's drafts made out to Mrs. Norton in a clerk's copperplate, folded in 3 and sealed. He opened one at breakfast. She watched him do it. He turned it to the light, read the figure, and put it inside his coat. "That is mine," she said. "It is made out to my wife," he said, "which is the same thing exactly." He did not say it cruelly. He said it the way a man reads out a rule from a book he did not write and rather approves of. He was, after all, a barrister. He knew that a married woman in England had no separate legal existence at all, that everything she earned, everything she owned, everything she wrote, belonged from the moment of the wedding to the man across the table. Coverture. Her person was covered by his. She had been arguing with a rule for 2 years without once looking it up. The draft stayed in his coat. He put jam on his toast. There was a playbill in the house, framed from Drury Lane, with the Sheridan name on it in letters an inch high, and it had a tear across the corner where it had come off a wall in a hurry sometime in the previous century. She kept it in the back drawing room. He never mentioned it. He looked at it a good deal. The first time he struck her, they had been married under a year. It came out of an argument about her sister, and it ended at a door. She got behind the door. He put his weight against it, and the panel took the shock, and she heard him breathing on the other side. And then she heard him go down the stairs, and then she heard the front door, and then nothing at all for a long time. In the morning she washed her face carefully at the basin and did her hair a little lower on the left, and came down and poured his coffee and asked whether he would want the carriage. He said he would want it at 11. They discussed the fishmonger's account. Neither of them said anything else about it that day or after, and it happened again in the 2nd year and in the 3rd. And there came to be a rhythm to it that the household learned the way a household learns which stair creaks. Hannah Kettlewell, who had dressed the boys since the cradle, developed a habit of taking them up early. Nobody had asked her to. The children were the thing that kept Caroline in the house. That was not sentiment, it was arithmetic. A wife who left her husband in England in 1830 left with what she stood up in and saw her children when he permitted it, which was never, and she had read enough of her husband's profession by then to know it. Fletcher was born in 1829, Brinsley in 1831, William in 1833. 3 sons, and every one of them, in the eye of the law, his. She told Selina Fanshawe once that she had made a bargain at 19 without reading the paper it was written on. Selina said she might read it now. "I have," Caroline said. "It is very short. It says I am not there." The friendship with Lord Melbourne was George Norton's own idea. That is the part that has to be said plainly, because everything after it turns on it. In 1830, the Whigs came in and the Tories went out, and George Norton lost his seat and his salary in the same season, and the household at Storey's Gate began to hear about economy at breakfast. Caroline knew people. Caroline had always known people. Her husband sat her down and explained to her patiently, as one explains a thing to a woman, that the new Home Secretary was said to admire her verses, and that a letter from her would not be improper, and that a man in office had a great many small appointments in his gift. She wrote the letter. William Lamb, Lord Melbourne, called at the house within the week. The magistracy came through afterwards. A police magistrate's post, £1,000 a year, and George Norton took it and kept it and lived on it. And he had it because his wife had asked for it, and because the man she asked said yes. Melbourne came nearly every day after that. He was 56. He had been Prime Minister since 1834, and he had buried a wife who had made him a byword, and a son who never grew into his mind. And he came to Storey's Gate in the middle of the afternoon and sat in a chair by the fire with his legs out and let her talk. That was the whole of it, so far as the room could see. She talked. He listened, and now and then he said something dry that took the wind out of whatever she was working herself up about. And she laughed, and he looked pleased in a small, tired way, and the fire burned down, and he stayed too long and went. He brought no flowers. He never once wrote her a letter longer than a line. "You are in a rage about the poor law again," he said one afternoon, without opening his eyes. "I am in a rage about a boy of 9 in a mill." "Yes," Melbourne said. "You would do better not to be. The world is very well as it is, and anybody who tells you he can improve it wants something." He opened one eye. "Write it anyway. You write it better than the men who believe it." There were servants in and out with the tea things the entire time. There was Hannah on the stairs with William on her hip. "The door of that room," Caroline said afterwards, "was never once shut." And she said it as though it were an argument. And it was not an argument, because the law did not care about the door. She called him Lord M when nobody was in the room. It is a small thing. It went into a courtroom later. George Norton began that year to sit with his accounts in the evening. He had the magistracy and he had debts, and the two did not meet. And there was a brother with a barony and a coldness in the letters from that quarter. His wife's earnings came in and went into his coat, and was still not enough. He read the newspapers on the government very carefully. He wrote to a solicitor and had a letter back and read it twice by candle, and then sat with it flat on the table under his hand, and did not move for some while. A husband could sue another man for the use of his wife. That was the phrase, criminal conversation. Not a divorce, a claim in damages, one gentleman against another, for the injury done to his property. The wife was not a party. The wife could not testify. The wife could not be heard at all, since a wife had no legal existence to be heard with. And the sum was whatever 12 men thought the property was worth. The Prime Minister of England was a wealthy man. Norton put the letter in the drawer and turned the key, and went upstairs, and was very pleasant to her at dinner. Pleasant in a way she had not seen in some years, and she was so grateful for it that she talked to him about the boys until the candles were low. He asked that spring how often Lord Melbourne called. The Prime Minister of England sat in a chair in South Street with his boots off and a book of sermons open on his knee, and did not read it. It was late. The coals had gone to the red stage where they give heat and no light, and the room smelled of cold candle tallow and the leather of 100 books he had bought and not opened. He was 56. He had a habit, when alone, of putting his hand flat over his eyes, and he did it now, and stayed like that a while. He had been ruined once already by a wife. That was the plain history of William Lamb, and everyone in London knew it, and nobody said it to his face. He had married Caroline Ponsonby in 1805, and she had gone mad about Byron in front of the entire kingdom, in print, at parties, in letters that were read aloud for sport. She had put on a page's costume and sent a lock of her own blood-stained hair, and Lamb had stayed married to her through all of it, and buried her in 1828, and never once complained aloud. The complaint had gone somewhere else. It had gone into the shrug. It had gone into the way he had of saying that nothing much could be done about anything, and that the world was tolerable if one did not poke it. There was also a son. Augustus was a grown man now, and would never be more than 4, and Melbourne carried him downstairs himself when the fits came. He had no other family to speak of. He had a cabinet. The government was not strong that year. The Whigs held on by an arrangement with the Irish members that could be broken any Tuesday a man in a bad temper wanted to break it. The majority in the Commons was a number one could count on one's fingers, and the King disliked him personally, and the Lords disliked him on principle, and the whole administration rested on the King's patience, which was known to be short, and on the Prime Minister being a man nobody could get hold of. Nobody could get hold of him. That was the entire trick of him. The colleague came at 11 o'clock at night, which was itself a message, and stood by the fire and would not sit. "You are still going to Story's Gate?" "I am. Every day." "Not Sundays," Melbourne said. She goes to her mother on Sundays. The colleague did not laugh. He said the thing he had come to say, and he said it in the flat way men use for the money end of a matter. Norton was a barrister. Norton was a police magistrate on a salary the government had put in his pocket, and he was in debt, and he had been talking. A husband did not need to prove anything worth calling proof. A husband did not need his wife's consent, or her presence, or her word. She could not be a witness in it. She was not a party to it. She had no standing to be in the room. He needed a jury of 12 men and a footman who would swear he had seen a door shut. And what he got, if he got it, was money.
They have a name for it,
The colleague said. Criminal conversation. Very old. Very useful. It is an action in trespass, in point of law. The wife is the property trespassed upon, and the damages are what the property was worth to the husband before you got at it. And if the Prime Minister of England is dragged through Westminster Hall on that footing, the government does not survive the summer, and neither do you. Melbourne turned a page he had not read. You are telling me she is a woman I visit. I am telling you what a jury will be told. The coals settled. Somewhere below, a door.
Melbourne took his hand from his eyes
And looked at the man for a moment with an expression that was almost cheerful, and said that he had known her when she was a girl, reciting her grandfather's lines at a party, that she was the cleverest creature in London and married to a fool who beat her, and that she had nobody, and that if the whole of English public life could be brought down by a man of 56 drinking tea in an open room with a woman who made him laugh, then English public life had less to it than he had supposed. Then you will stop going. I did not say that. Say it now. He did not say it now. He said the thing he always said, which was that these matters generally settled themselves if one left them alone. And the colleague went away at midnight, unsatisfied, and Melbourne sat on. Then he took a sheet and wrote to her, and it took him a very long time to write 4 lines. He did not say he would not come.
He said he might not come so often,
being much taken up with business, and that she was not to mind it. He read it over. He thought about the girl at the party and about a woman putting a boy's papers face down on a desk when he called, and about what a jury of 12 tradesmen would make of the word often. Then he sealed it and rang and had it sent, and put the sermons on the table and went up to bed. And that was the whole of what one of the great men of the age did for his friend that night. He kept the visits up. He only cut them by half. That is the sort of courage most men have. She was at her desk by 7 in the morning, which nobody in London would have believed of her. The picture of Caroline Norton was the one the drawing rooms had. The dark head thrown back, the low voice, the room turning to her the way iron filings turn. The other picture had no witnesses.
it was a woman
In a dove-grey gown turned at the cuffs, at a table by a window in Storey's Gate, with her feet on a footstool because the floor was cold, writing for money before the household was up. She wrote fast, and she wrote well, and she was paid properly for it. She had edited La Belle Assemblée. She had the Court magazine. She had verse in the annuals at a guinea a page, and a novel with her name on the spine. And by 1835 she was making, by her pen alone, more than a good many men made by a profession, and every shilling of it, from the moment the ink dried, belonged to the man asleep upstairs. The banker's draft came on a Thursday, in an envelope with the publisher's seal. She did not open it at breakfast that time. She took it up to the desk and put it under the inkwell and looked at it, and the thing under the glass said, Mrs. Norton, in a clerk's copperplate, and the name was hers, and the paper was not, and there was no court in England where she could have said one word about the difference. Her earnings were his. Her copyrights were his. If she had walked into a bookseller's and bought a copy of her own novel with a coin from her own hand, the coin, the novel, and the hand were, in the eye of the law, all his. She wrote 3 pages that morning on a debtor's child in a workhouse. At Lansdowne House that same season, she stood up at the end of a table and did her grandfather for them, the whole of a scene from The Rivals, with all the parts, and a duke laughed until he had to put his glass down. She was asked for. Hostesses wrote to her a month ahead. She wore the same gown twice in a fortnight and got away with it because nobody in the room was looking at the gown. She came home from those evenings at 1 in the morning and took her shoes off on the stairs.
The night in 1835
That the house learned to date things from began over nothing at all. It began over an invitation, and it went on to money, and from money it went to Melbourne. And it was not that he believed anything then, it was that she had been laughed at with, and he had not. Hannah Kettlewell heard the pitch of it from the first landing and went up, not down. She had dressed all 3 boys since the cradle. She took Fletcher's hand and had William on her hip before the noise reached the 2nd floor, and she shut the nursery door and put her back against it and told them, in a voice with nothing in it, that they would have the story about the horse. Below, a chair went over. He had her by the hair against the door frame, and the frame was oak, and he was saying something over and over that had the word damned in it, and no other word she could afford to keep. She did not scream because of the servants. That was the calculation she made with her scalp against the wood, the servants, and it was the calculation of a woman who had been married 8 years. Then the sound of the fire irons going down. The story about the horse went on upstairs. Hannah Kettlewell told it very slowly and did not stop. In the morning she came down at the usual hour, with her hair dressed a little lower on the left, and poured his coffee and asked whether he would want the carriage, and George Norton said he would want it at 11, and read his paper, and neither of them said anything about it at all. That afternoon she sat by the fire in the back drawing-room with the mending basket and turned a cuff. The needle went in and out, and the light went across the boards to the fender and stopped there. She bit the thread. She smoothed the cuff flat on her knee with the side of her thumb. Twice. Then she put the shirt on the pile and took up the next one and did the other cuff. And the coals shifted once, and the clock in the hall struck 4, and she went on to the end of the basket. Selina Fanshawe said the word out loud because somebody had to. Leave him. And go where? To your mother. To me. Caroline, to anywhere at all. With what? She was not angry. That was the frightening part of it. She said it the way one reads a timetable. She could not sue for a separation on cruelty without money, and she had no money because her money was his. She could not take the boys because the boys were his, as absolutely as the chairs, as the plate, as the dog. If she went out of that door tonight, he could bar it behind her by law, and keep the children by law, and take her earnings for the rest of her life by law. And the whole of English justice would stand behind him, with its arms folded, and there was not one court in the kingdom where she could be heard, because in the eye of that law she was not there to hear. He would not keep them from you, not their mother. He would keep them from me, Caroline said, because they are the only thing he has that I want. She stayed. It was arithmetic, and she had done it more than once, at that same fire, with the basket on her knee. Fletcher was 6 then, and had begun to notice things, and to be quiet about them, which was the unsettling part. He had taken to reading the room from the doorway before he came into it, the way a much older person does. Easter of 1836 fell at the beginning of April, and she went to her sister for a few days, and she left the boys behind because she was coming back on the Monday. That is the whole of it. She was coming back on the Monday. George Norton had spent the winter with Josiah Prentice, who was 48, and had drawn every Norton document for 20 years, and never yet softened a clause. They sat in the front room at Story's gate with the candles between them, and Prentice laid it out the way he laid out an assignment of lease. The children were the father's. There was no application any court would entertain to the contrary, none, in the whole body of English law, because there was no such thing as the mother's claim. If the boys were out of the house and out of the county, and in the keeping of a relation who would not open the door, then that was the end of the matter, and no writ would run. And she may do what? She may write to you, Prentice said. George Norton had been the joke of every table he had ever sat at with his wife. He knew it. That is the thing that has to be said for him once, and it is not much, and it is true. He was not imagining it. They came for her, and they were civil to him. His own appointment, the £1,000 a year he lived on and was proud of, had been got for him by his wife, asking a favour of a man who had then made a habit of sitting by his fire. And every clerk in Westminster knew how the Honourable George Norton had come by his post, and the knowledge sat in him and turned day after day for 4 years. He was 36, in debt, laughed at, and married to a woman the Prime Minister of England came to see in the afternoons. He did not tell Prentice any of that. He asked about the money. They took the boys on the Saturday. Hannah Kettlewell was told at 10 that the children were to be dressed for a journey, and she asked where, and was not answered, and she dressed them because she was a servant in that house and had been since Fletcher was in long clothes. 3 coats off the pegs. She did Brinsley's buttons twice because he would not stand still, and Fletcher put his own on and did not ask one question, and stood by the door with his hands at his sides. William was not yet 3, and did not understand about journeys. He understood about coats. He was pleased. She got him into the sleeve and turned him round, and he had his soldier in his fist, the tin one, the painted one, and she said he could not carry it in the carriage, and he opened his hand at once, because he was good, and it went down on the boards by the fender, and rolled a half-turn, and stopped. Then a man's voice from the stairs said to bring them down now. Fletcher looked back at her from the top step, not at the room, at her. Hannah Kettlewell went down after them with William's other cap in her hand, and did not get to the door in time to give it to him, and the door was shut from the outside, and she stood in the hall of that house and heard the wheels go, and the house was quiet for a long, long while. She went up. The pegs were at a child's height, 3 brass hooks screwed into deal, and there was nothing on them. She left the soldier where it was. She could not have said why. Caroline came back on the Monday, and there was a servant at the door who would not let her past it. The writ was served on Lord Melbourne within the fortnight. The Prime Minister of England was informed, in the King's name, that the Honourable George Chapel Norton complained of him in an action of trespass, for that the defendant had debauched, seduced, and carnally known the plaintiff's wife, whereby the plaintiff had lost her comfort, society, and assistance, and the damages laid at £10,000. The wife was not a party to it. The wife could not be called, could not be sworn, could not answer, could not be in the room. The thing was to be tried between the 2 gentlemen, over her head, about her body, in open court before a jury of 12, and the newspapers were to have every word of it. The date was set for June. On a morning in June 1836, the woman whose body was the subject of the case sat in a borrowed room, with a cup of tea going cold at her elbow and no reason on earth to get up. The clock was the trouble. She could hear it, and she could not stop hearing it. And she knew the hour the court sat, and she knew the mile between that hour and this room, and there was nothing at all for her to do in the whole of the day but count it out. She had dressed. That was the absurdity she noticed and could not get past. She had put on the dove grey and had her hair done, and there was nowhere to go. The action was Norton against Melbourne, her husband against her friend. Two gentlemen in Westminster before the Lord Chief Justice, with counsel and a jury, and every newspaper in England taking it down in shorthand. And the entire matter of it, every word, every hour, every servant's oath, was about her. Her conduct, her body, her letters, her name. She was not a party to it. She could not enter the building. She could not be sworn. She could not answer one syllable of what was said, because the law that made her husband's suit possible was the same law that said she had no separate existence with which to speak. Selina Fanshawe came at 10 and found her sitting exactly as she had been at 9:30.
You will make yourself ill.
I am the only person in England who is not going, Caroline said. The fishmonger may go. My own footman may go, if he can get in. I am the thing they are arguing about, and I am not admitted. She turned the cup on its saucer, a quarter turn. Do you know what Follett will say about me at noon? No. Neither shall I, until I read it in the paper with my breakfast, like everybody else. She did not cry that morning. She did the thing she always did with her hands, which was to find something to put in them, and what she found was a stack of proof sheets from the printer, and she read them twice without taking in a word, and marked 1 comma. A mile away, they were queuing in the rain. The Court of Common Pleas was not built for this.
It was a working court,
Panelled, low, smelling of wet wool and lamp oil, and the breath of 200 men packed into a space meant for 80. The barristers' benches were full of men with no business there at all, and the reporters were 4 deep at the table with their knees jammed and their pencils out, and a gentleman of some fortune had, it was said, paid a guinea for a place on a window-sill. Lord Chief Justice Tyndall came in at 10, and the room stood and sat and settled like water. The Prime Minister of England was not in it. He had that right, being a defendant in a civil action, and he took it. He was at his desk in Whitehall, doing the business of the country, or holding a pen over it, and every man in the court knew where he was and what it would cost him if this went the other way. The Whig government sat on a majority you could count on your fingers. 12 tradesmen in a box had it in their hands until dinner time. For Norton. Sir William Follett, who was the finest advocate at the English bar and knew it, and who had never once in his life raised his voice. For Melbourne, the Attorney General, Sir John Campbell, who sat with his arms folded and did not take a note for the first hour. Follett opened. He was quiet, and he was reasonable, and he was, for the first 20 minutes, almost apologetic. A plaintiff of position, a wife of great gifts and great charm, a defendant of the highest station in the kingdom, and a duty on the plaintiff, however painful, to vindicate his own honour in the only court where it could be done. He said the word honour perhaps 4 times. He never said the word money once, and the sum was on the record in front of every man there. £10,000, laid as damages for the loss of the comfort, society, and assistance of his wife. That is what the action was. Not a divorce, a trespass. A man was suing another man for the value of a thing he owned, and the thing had a price on it, and the price was £10,000. Follett came to the evidence, and the evidence was servants. They had been in the Norton mews, and the Norton kitchens, and the Norton passages, and most of them were not there any longer, and the ones who were still in place had been talked to at some length by Mr. Josiah Prentice, who had drawn every Norton document for 20 years and never yet softened a clause. Some had been dismissed. Some had been dismissed and then found again. Follett laid it out very carefully, that no one, of course, would ask the court to believe that anybody had seen anything, that the case was one of circumstance, that a jury of Englishmen knew what circumstances meant. He then called Amos Studley. Studley was 24 and had been a groom in the Norton mews, and he came into the box in a coat that had been brushed for him that morning by somebody who cared how it looked. He took the book. He gave his name. He said he had seen Lord Melbourne's carriage in the street a great many times, and Lord Melbourne go in at the door, and the door of the drawing-room shut. Follett let a silence sit on the word shut. Then he sat down, and the Attorney-General uncrossed his arms and stood up, and asked Amos Studley how long it was since he had been in the Honourable George Norton's service. It took 11 minutes. Campbell did not shout. He asked when Studley had left the service, and why, and who had sent for him since, and how many times, and whether anybody had spoken to him about his evidence, and where, and whether anything had been said about his expenses. Studley said he could not rightly recollect. Campbell asked whether he could rightly recollect the year, and Studley gave a year, and Campbell held up a paper and asked him to look at it, and Studley looked at it and said that he might be out by a 12-month.
A 12-month.
Thereabouts, sir. You are certain to the hour what you saw through a door you were not behind, and you are out by a year on the day you left the house. The court laughed. Tyndall did not stop it, and that is the moment the thing turned. A laugh is not a ruling, and it goes in no report. But every man at that reporter's table heard the room change hands. And Follett, who had never once in his life raised his voice, drew a line through something on the page in front of him, and did not look up. They put in another. It was worse. He had been dismissed for cause, and Campbell had the cause. They put in a maid, Dinah Rudkin, 19, who had been a parlour-maid in the house, and who said, when pressed, that she had seen her mistress's hand on Lord Melbourne's arm in the hall, and Campbell asked her whether she had ever seen her mistress's hand on the arm of any other gentleman in that hall, and she said yes, a great many, and the court laughed again. Two of them contradicted each other on the same afternoon in the same room, about the same door. Then Follett came to the letters. This was the heart of his case, and everybody knew it. The Prime Minister of England had written to Mrs. Norton constantly for 4 years. The letters had been taken out of her desk in her absence, and they were in court, in a bundle, tied, and Follett rose to read them to the jury, and the reporters at the table turned their pages over and licked their pencils, and 200 men leaned in. He read the first one. "How are you?" He read it in full, because there was no more of it than that, and a note about a book, and the words, "I shall call today." He read the second. It asked whether she would be at home on Wednesday. He read the third, which regretted that he could not come, being detained. There was one that said she had been foolish about a paragraph in a newspaper and should pay it no mind. They ran to 4 lines. Some ran to 3. They were the letters of a busy man of 56 to a woman he liked, and they were not signed with anything, and there was nothing in a single one of them that could not have been read aloud at a christening. Follett read them all. He had no choice. He had told the jury they were coming. The reporter's pencils stopped one after another down the table, and the room got very quiet, and a man on the windowsill who had paid a guinea began to laugh and stopped himself. They had been kept, though. She had kept every one. 4 years of 4-line notes in a drawer in a desk, and a man like Sir William Follett could have done something with that, if he had been given anything else at all to put beside it. But he had a groom out by a year, a maid who had said the opposite of what she was called to say, and a bundle of paper in which the greatest man in England asked a woman whether she would be at home on Wednesday. He closed his case a good deal earlier than anybody had expected.
Campbell got up.
He spoke for a while, and then rather less than he had meant to, because he could feel it too. He said the plaintiff had come into court to sell his wife by the yard, and had brought no yardstick. He sat down. Tyndall summed up, and the summing up was short, and the last thing he said to the jury was that they would find no evidence in the case, and that they might consider whether there was any at all. The foreman did not leave the box. He did not need to. The 12 of them put their heads together in the space of half a minute, standing where they were, in front of 200 people, and the foreman turned round and said, "For the defendant," and it was done. The Prime Minister was acquitted at once and entirely. The action of Norton against Melbourne, laid at £10,000, went out of the world in one breath. It was still light. The whole thing had taken a single day. They were shouting it in the street before the court was empty. It reached South Street inside the hour, and Melbourne, who had been holding a pen over the business of the country all day, put the pen down and did not say anything for a moment, and then asked mildly what the jury had taken over it. Nothing, he was told. They never left the box. He said that was very good of them, and went back to his papers, and kept his hand flat over his eyes for a while first. It reached Caroline at 7. She stood up when Selina came in with it, and heard it out, and asked the only question she had. And the letters? Read in open court. All of them. All. Caroline, there was nothing in them. That is the whole point of it. There was nothing in them at all. Yes, Caroline said. She went to the window. The evening had come up fine after the rain, and there were people going along under it, ordinary people going to their dinners, and by morning every one of them could buy for a penny what William Lamb had asked her about a book in 1834, with her name over the top of it, and her drawer emptied onto a table in front of 200 men. She had won. That was the thing she had to hold in her hand and turn over. Her husband had gone into the Court of Common Pleas and sworn her a whore, and the jury had said no, and had said it so fast they did not sit down. And she had been vindicated by 12 men she had never met, in a room she was not allowed to enter, and it had bought her exactly nothing. Not one thing. She was still his wife. The acquittal did not touch it. There was no adultery proved, therefore there was no ground for anything. Therefore the marriage stood, and she stood inside it where she had always stood, which was nowhere. Her money was his. Her copyrights were his. The house was his. She could not sue him because a wife cannot sue her husband, being the same person as him in law, and that person being him. And the children were his. The jury had not been asked about the children and could not have been. There was no proceeding in England in which a mother could ask about the children. Fletcher was 7. Brinsley was 5. William was not yet 3, and she had last had her hands on him in the week before Easter, and she did not know the name of the house he was sleeping in tonight. Somewhere in the country, a nursery had 3 brass pegs at a child's height, with nothing on them, and a tin soldier on its side by the fender, where a good child had dropped it, when he was told he could not take it in the carriage. That was what she had won. She stayed at the window until it was dark, and there was nothing to see but the glass, and then she said, in the voice of a woman asking about a fishmonger's account, whether there was any word of the boys. There was not. The newspapers had it all by morning, and they had George Norton too, which was the part nobody had arranged. He had gone into court to be a wronged husband, and had come out in a single day as the man who had put his own servants in the box to swear away his wife, and had been laughed at for it in front of the whole bar. The letters were the ruin of him. They were printed everywhere, all of them, in full, and they were so completely harmless that the printing of them was itself the joke. Column after column of the Prime Minister asking whether Mrs. Norton would be at home on Wednesday, and under it the sum, £10,000. The papers put the figure in. They always put the figure in. A man who had valued his wife's comfort, society, and assistance at £10,000, and been told by 12 tradesmen in half a minute that he could not have a penny of it. There was a caricature in a shop window within the week. He was in it. He was not the injured party in it. He kept the magistracy. He kept the boys. Caroline went to a lawyer in the autumn because she had begun to understand that she did not know the walls of her own prison. And she was the granddaughter of Richard Brinsley Sheridan, and she had spent 9 years married to a barrister, and she had never once read the thing itself. He was civil. He gave her a chair and heard her out, and then he went through it, in order, the way a man reads out an inventory. She could not divorce her husband. There was no such thing as a divorce in an English court. The marriage could be dissolved only by a private Act of Parliament, 1 act for 1 marriage. A bill passed through the Lords and the Commons at a cost of thousands of pounds, and it had been done, in the whole history of the kingdom, for a woman perhaps 4 times, and each of those on the ground of adultery aggravated by incest or bigamy. And she had no thousands of pounds because my money is his, because your money is his. She could not obtain a separation without proving cruelty in the ecclesiastical courts at a cost she could not meet, and if she obtained one, it would not give her the children. She could not have the children, not the youngest, not any of them, not for an hour, not by any writ or petition or application known to English law, because the father's right was absolute, and the mother's right was not a thing that existed to be weighed against it. If George Norton chose to hand his 3 sons to a stranger in Scotland and never let her see them again, no court in England would hear her, because there was no court in England in which she had standing to be heard. There must be a case. There must be one case somewhere, some woman. There is no case, the lawyer said. There is no ground for one. You are not a person the law can hear, madam. You are your husband's wife. He was not unkind about it. That was the thing she took away with her. He was not unkind, and he was not wrong, and he had said it the way one says a thing that has always been true and always will be. And George, having lost, went for the money. The suit had cost him, and the caricature had cost him more, and the one asset in the world that reliably produced was his wife's pen. He instructed Prentice. The publishers were written to, formally, on paper, and informed that the copyrights in the works of Mrs. Norton and all sums arising were the property of the Honourable George Chapel Norton, and were to be accounted for to him. And it was not a threat, and it was not a bluff, and there was not one line of English law against it, because it was simply true. She could go on writing for the rest of her life. he would go on being paid for it. Selina found her that night with the bundle out on the desk. Not the papers, the other bundle. 4 years of 4-line notes in a hand the whole country now knew, and the ones already printed were nothing, and the ones not printed were nothing too. But there were things in them, small, worldly, indiscreet things, a remark about the king, a remark about a colleague's wife, the kind of thing a tired man says to a friend at 5 in the afternoon with his boots off. Any publisher in London would have paid. Any publisher in London would have paid a great deal, and George could not have touched a farthing of it if she had taken the money and burned it. And the man who had cut his visits by half to save himself would have learned what it cost. She had them squared up. She had the candle at her elbow. She sat there a long time. "Do it," Selina said. "He left you standing in it. He sat in Whitehall and let them read your desk out loud. He came every day for 4 years when nobody else in London would have crossed the street for me. He came by half after that." "Yes," Caroline said, "he did." She sat a moment longer. Then she took the bundle and put it back in the drawer and turned the key, and put the key in the pocket of the dove-grey gown, and it stayed there. The other temptation was the harder one, and it took her until Christmas to refuse. George's terms were on paper, and they were simple. Come back to the house, live in it, be his wife in it, and she might see the boys. That was the price. 9 years in a courtroom and her name in every paper in England, and he was still offering her the only currency he had. And it was the only currency she wanted, and it would have been so easy. A carriage, an evening, a door, and William's arms round her neck by Thursday. She got as far as writing the letter. She had it on the desk in front of her, done and dry and unsigned, and she thought about the door frame and the fire irons and what Fletcher's face had begun to do in that house before he was 6, and she put the pen down. She did not sign it. She never went back, which left her in a room in the winter of 1836 with nothing at all. No husband she could shed, no money she could keep, no children she could claim, no standing to bring one action in one court in the kingdom, and a name that could be had for a penny at any stall in the Strand. They had taken everything the law knew how to take. That was the entire trouble with the law. It had been written by men who could not conceive that she had anything else. She had a desk, she had ink, she had the one thing that had made 200 men lean in and a duke put his glass down. And it was not property, and it could not be seized, and there was no writ in England that ran against it. And George Norton could take every shilling it earned for the rest of her life and still not own the thing itself. She sat down. She pulled the candle nearer and squared the paper and took the pen out of the stand, and the sheet in front of her was blank. And she did not write to a publisher, and she did not write to Melbourne, and she did not write to her husband. She began to write to the men who made the law. The word they used was unsexed. It was in the reviews, and it was in the drawing rooms, and it was said, with great courtesy, to her face. A woman had written a pamphlet about the law of England. Not a novel about a woman. The law itself, sections and precedents, and the plain machinery of it, published, with her claim as a mother on the front of it, and the polite verdict of the polite world in 1837 was that whatever else the thing was, it was not a woman. The old matter came back with it. It came back in the 3rd paragraph of every notice. A person who had been read out in open court had no business lecturing Parliament on motherhood, and the letters were only a year old, and everybody still had them by heart. And there was a hostess in Mayfair who had loved her for 9 years, and now had a footman say she was not at home. She went on writing. She wrote in the mornings, at the desk, with her feet on the footstool because the floor was cold, and she had the sections of the law copied out beside her in her own hand, because she could not afford a clerk. Observations on the natural claim of the mother to the custody of her infant children. That was the title. It ran to a few dozen pages. It was, from end to end, an argument, and there was not one sentence of pleading in it, and it sold to the people it was sent to and to nobody else. It did nothing at all. That was the education. The second one she signed Pierce Stevenson. She had learned the lesson the reviewers taught her, and she had learned it exactly. The argument was sound, and the argument was unanswerable, and the argument could not be heard while her name was on it. So she took her name off. A plain letter to the Lord Chancellor on the Infant Custody Bill, 1839, by Pierce Stevenson, Esquire, a gentleman who did not exist, writing on the rights of mothers, and the gentleman who read it thought it a very able production, and one of them said in print that no woman could have written it. She let him say it. She had a bill to get through the Lords. Thomas Noon Talfourd was a sergeant at law and a member of Parliament, and had written a tragedy that had done rather well at Covent Garden, which is possibly why she went to him and possibly why he listened. He had seen the courts do this. He had stood in them and watched a father hand a child of 2 to a servant and walk out, with the law standing behind him with its arms folded. And there was nothing a judge on the bench could do about it, and Talfourd had gone home and thought about it, and done nothing for a year. Then a woman came to his chambers with a pamphlet nobody had read. "They will say I am your author," he said. "They will say worse than that." "Yes," Talfourd said, "they will." He turned the pages a while. Then he asked her what she wanted the bill to do, and she told him, and he took a pen and wrote it down as she said it, which was the first time in 3 years that a man with any standing in England had written down a word she said as though it were evidence. He brought it into the Commons, and it went up to the Lords in 1838, and the Lords threw it out. The Lord Chancellor was against it. The objection was that it would put a premium on female adultery, that a wife who wanted her children need only misbehave and go to law and be given them, that the father's absolute right was the only thing holding the English family together, and that to let a mother petition for a child under 7 was to hand the domestic hearth of the kingdom to any woman with a grievance and a solicitor. They said this to each other for an evening, and then they voted, and it was thrown out, and she read the division in the paper the next morning with her tea going cold. She wrote the plain letter that winter. They carried it in 1839. The Custody of Infants Act. A mother against whom adultery had not been proved might petition the Lord Chancellor for the custody of her children under the age of 7 and for access to the older ones. A small, hedged, grudging thing, the first crack in the father's absolute right in the whole history of English law, and it went on to the statute book in August, and it is there still. The boys were in Scotland. That is the flat fact, and it does not need dressing. George Norton had put his 3 sons beyond the Tweed, and the Act was an English statute, and an English court's writ does not run in Scotland. And the law that Caroline Norton wrote and got a stranger to father and pushed through 2 houses in 3 years against every man of standing in the kingdom could not fetch her one of her own children for 1 hour. She had written it for other people's sons. She got other people's sons. Later she put down what she thought the whole of it came to, and she did not put it prettily. She had not asked for her rights, because she had no rights. She had only wrongs. She let that sentence stand, in print, over her own name, and she never took it back. In 1842, William was 9. He was at the place his father kept the boys in the country, and he came off a horse, and it was nothing, a graze on the arm, a scratch a boy gets and shows off at supper. Nobody sent for a doctor. Boys come off horses. The arm was tied up by whoever was nearest, and the household went on with its day, and the thing turned quietly over about a week, the way such things did before anybody understood why. By the time it was understood, it was in his blood. George Norton sent for her then. He had not written to his wife in the ordinary way in 6 years, and he wrote now, in a hurry, and the letter said, "Come," and it did not say how bad it was, because he could not put it on paper. She went north the same hour. She got a chaise and changed horses, and went on through the night and through the next day, and did not sleep in it. And there was a stretch in the dark where the boy she was going to was 3 years old in her head and holding a coat sleeve. She was too late by some hours. She came into a house that had already gone quiet. That is the thing she wrote about afterwards, once, briefly, the quiet. A house does not sound like anything else after. And she knew what it was from the hall, before a single person came out to her, and she stood in the hall and took her bonnet off, because there was nothing else to do with her hands. He had been asking for her. They told her that, meaning it kindly. Fletcher was 13, and Brinsley was 11, and they had been in the house through all of it, and they came and stood with her, and she did not know either of them very well. She saw him. She was not kept from him then. Nobody in that house had any reason left to keep her from him, and she had him to herself for as long as she wanted, which was a considerable while. And there is no account of it, and there ought not to be. There had been a tin soldier on a nursery floor in Westminster in 1836. He had it in his fist when the nurse turned him round to get him into his sleeve, and she told him he could not carry it in the carriage, and he opened his hand at once, because he was good, and it went down on the boards and rolled a half-turn and stopped, and he was not yet 3, and that was the last morning she had him. She was 34 when she buried him. George Norton let her have the 2 who were left after that, in part, in a fashion, when it suited him. That is exactly the size of it. There were visits and holidays and years when there were not, and no court had made him do any of it, and none could have. He did it because a child had died, and he was frightened, and he went on being what he was, and the arrangement held, or did not hold, at his pleasure for the rest of their childhood. They grew up in his house. They grew up polite to her. She never got a divorce. There was none to be had. She lived out the whole of it as the wife of the Honourable George Chapel Norton, and he took her earnings whenever he could reach them, and in the 1850s he was in court again, arguing that he was not liable for a bill because his wife had run it up. And she stood in that courtroom. She was permitted in this one, and told the room that she did not exist in law, that she had no property, no name, no ability to sue, and that everything she earned by her pen was his, and that he might therefore pay the tradesman. The reporters wrote it down. It went into the papers, all of it, which was the only court of appeal she had ever had, and the bills that came after, a married woman's property, a divorce court a person could actually use, came out of the noise she made about her own ruin for the next 20 years. She wore black a good deal. She had a heart that gave her trouble by 1860, and she went on writing anyway, because the money was needed, and because the alternative was to sit still. George Norton died in 1875. She was 67, and she had been his wife for 48 years, and she was, from the hour of his death, For the first time since she was 19, a person. Able to own a coin, sign a paper, keep a shilling of what she earned. She married Sir William Sterling Maxwell in March of 1877. He was an old friend, and it was a quiet thing, and she had waited half a century for the legal right to do it. She died in June, 3 months after.
The two remaining boys
Outlived her by very little, and the law she pushed through the Lords in 1839 went on working, year after year, in courtrooms she never entered, for mothers who had never heard her name and had no reason to. If you want more of these, the real women of the English peerage and the law they lived inside, this channel is where they are. There is one more thing to say, and it is small. She was asked at the start of all of it, in the doorway of an emptied nursery in 1836, the only question that ever mattered to her. How does a mother, the law says, owns nothing, get her sons back? The honest answer is the one nobody wants. She got the law back. She got it for every mother in England, and she got it 3 years too late for herself and out of reach besides. And the youngest of the three, the one who was not yet 3 that spring, she never held again. They swept the nursery at Story's gate at some point that year, as one does. There was a tin soldier on its side by the fender, and somebody's broom went round it, and then a hand picked it up, and where it went after that, nobody wrote down.